You are Christopher Flores. Mr. Flores, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
On December 29th, 2024, an officer initiated a traffic stop after observing a vehicle change lanes 2 separate times while failing to signal. The vehicle was speeding 58 miles per hour in a 30-mile-per-hour zone and passing another vehicle in a no passing zone. The officer made contact with the driver, the defendant, and the rear defendant, who is the rear driver's side passenger. Upon contact, the officer observed in plain view the magazine portion of an AR-15 sticking out from underneath the driver's side seat in the back passenger area. The driver denied having any weapons in the vehicle. The officer walked back to his patrol vehicle to write a traffic citation for the driver, and when he returned, the magazine had been moved and was now lying next to the defendant in the back seat. The officer asked the driver again whether he had any firearms, and he stated he had 2 inside of a bag in the vehicle. The defendant stated that the guns were his and told the officer where the bag was. The officer located a bag containing 3 guns in the seat next to where the defendant was sitting. 1 AR-15 pistol lacking a serial number and 2 Glocks.
Mr. Flores, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to be in possession of any weapons. Do you understand? If you violate this condition, I'm going to revoke your bond. I'll put you in jail. No more PR bonds for you. How old are you, sir?
18, sir.
You're 18 years old. What do you do for a living?
I used to work. Right now, I go to school.
Where do you go to school?
Am I going to school, sir?
Where do you go to school?
McCarter High School, sir.
Okay. I'm going to appoint you a lawyer today, Mr. Flores, but no smoking weed, no possession of weapons. I'm telling you now, I'm going to be all over it. So if I find that you're violating any of these conditions, there's only one place you're going to go. You'll be doing school with me and back. Do you understand? All right. I need you to fill out an application for me. Or hold on a second. I've got one. I already got one. So what we'll do now is I'm going to have you sign a reset with Victoria. I'm going to have you take a seat in the jury box while we have you meet with a lawyer and meet with Fleischer for your bond conditions, and then we'll get you here shortly. Come on.
Right this way.
Good morning, Ms. Lebson. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 28th, 2024, the officer was dispatched to a target in regard to a theft in progress. The officer made contact with the complainant, the loss prevention officer, who stated the defendant entered the store, grabbed some Advil, went to the beauty department, put 2 lip glosses on top of the cart, made her way to a different aisle, picked out 5 air wicks, placed 4 of those air wicks in her purse, and grabbed 7 candles. The loss prevention officer further stated the defendant placed a bag over the candles to conceal them, went to grab eggs and hangers, and the complainant only paid for the eggs and hangers and the Advil at self-checkout, and the complainant observed the defendant pass points of sale without purchasing the other items concealed. The total was $188.83.
Got it. All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any target. If you violate this condition, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand? What do you do for a living, ma'am? What kind of money do you make a month? Do you have any children? No. Do you have the ability to hire a lawyer, ma'am? I'll have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. I mean, you have to meet the federal poverty guideline to be given a court-appointed lawyer. So I need to know everything about you, stocks, bonds, mutual funds, how much money you have in the bank, stuff of this nature, and then I'll take a look whether you qualify. All right, please. So Alex, if you can file, no going to target, please.
Target, just that particular target or all target? Yes.
I'm doing it right now.
Great. Thanks.
All right, Judge, next is page 19. Ridley, come on up.
Yeah, that's fine.
Good morning, Mr. Ridley. Sir, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 29th, 2024, officers were dispatched to a disturbance in a weapon at a residence in Harris County, Texas. The officer observed the defendant standing in front of the complainant vehicle, preventing her from driving away. The officer made contact with the complainant, who stated she and the defendant have been in a dating relationship for about 2 years, and the complainant stated she and the defendant got into an argument in his residence after he mentioned something about her children. The complainant stated she decided to leave and got in her vehicle, where she stated the defendant wanted his belongings out of her car, and the defendant had placed some of the groceries she bought on her car. At some point, they were arguing and attempted to break her driver's side window. The complainant stated she rolled down her window to prevent the defendant from breaking her window, and that the defendant reached into her vehicle and struck her in the left side of her face with a closed fist while she was sitting in the driver's seat. The complainant stated the defendant hit her in the left side of her face several times and that she felt pain.
I'm going to find that there's probable cause to go forward with the case, Mr. Ridley. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm ordering you not to have contact with this person. Do you understand? I will protect every person in my county. If I find that you violate any of these conditions, you become a danger to anyone else, I'm going to lock you up. Do you understand? A protective order has been issued in this case. I would get to know it. If you do something to violate this protective order, like go to the protected individual's house, have any contact with her. If you're in possession of a weapon, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. Do you understand? So get to know it and don't smoke any dope. Don't use any alcohol. How old are you? What do you do for a living?
I go to school right now.
Where do you go to school?
I was going to Summer Creek High School. My friend enrolled in Houston, Kansas Academy.
So what are you doing now? Are you doing nothing with your life?
No, I go to school, but
No. Are you actively enrolled in school? Yes or no?
actually not right now, but
So that's what's going to happen now. I'm going to provide you a lawyer. You must either get in school full-time or get a job full-time as part of your bond conditions as well. Do you understand?
not the reason I understand, but the reason I ain't in school, right?
No matter. When you have too much time on your hands, you become self-destructive. We need you to do something with your life so that you become something of yourself and with yourself, because you turn 40, 50 years old and you ain't got some kind of education or some kind of trade or some kind of working knowledge, you're going to end up on the street, no money. And this life sucks without money. Do you understand? If you don't believe me, go look in the jails. If you can provide him a lawyer, same thing. Hold on, not done. We'll set out 2 weeks, see where we go on, and then no dope, no alcohol. All the jazz and no weapons. All right, come on. You were Jessica Sanford. Ms. Sanford, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On September 29th, 2023, officer was dispatched to a disturbance call in Harris County, Texas, and met with the complainant, who stated he asked the defendant to leave his apartment multiple times, but she would not comply. The complainant had video footage of the defendant refusing to leave and mentioning something about darkness inside of him. And the complainant and the defendant were in a relationship, but the complainant had ended things earlier that day. The defendant locked the complainant out of his apartment, and the complainant showed officers an injury on the back of his neck that appeared to be nail scratches. The defendant barricaded herself in the apartment, refusing to leave. So in this case, Your Honor, the injury caused by the defendant, according to the complainant, would be the nail scratches on the back of his neck that he showed the
You
officer.
say you never told me that an officer said this, that he told this to an officer?
Complainant just showed an officer an injury on the back of his neck that appeared to be nail scratches. Let me read the full DIMS, Your Honor, and see if he mentioned something else.
We don't work on hunches.
Yes, Judge.
I don't. I never heard anything that don't, please.
So the full DIMS reads that the complainant advised of an injury he had on the back of his neck area that appeared to be nail scratches done by the defendant with their hands, causing the complainant to feel pain.
That's
Yes, Judge, and I apologize for.
okay. I just want to know, make sure that we're
Yes, Judge.
in the up and up. Ms. Sanford, I'm going to find that there's probable cause to go forward with your case. Do we know whether he wants to have contact with her or not? I know that you want to talk. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. Now's not the time. You will have the opportunity to fight. I promise.
I don't want to fight, sir.
Okay, don't say anything. I know, please. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. Just don't.
We've attempted, but we're unable to get a hold of her at this time.
Okay, so tell me, Ms. Sanford, are you working at this time?
But
I only want to know, are you working?
I haven't been able to because since I've been arrested, like
Stop.
I haven't been able to get any
I
of my
will provide you a
belongings.
lawyer today. I don't want you to say anything. I'm going to give you a lawyer. You can tell your side to the lawyer. Lawyers can talk to the DAs for you. But I've got so many people here. I mean, all these people will be witness to whatever you say, and they'll use it against you to prove guilt, okay? So just hang tight. Give me 20 minutes. I'll give you a lawyer. And you can tell your side to the lawyer, okay? I want you to understand, though, I don't want you to have contact with this person because I don't know if they want to have contact with you. They've been unable to reach him. Until that we know that she or he wants to have contact with you, don't. Trust me, I'm trying to help you, okay? I promise. We're not here to do anything bad. I'm going to help you as much as I can, okay? But I need you to be patient with me, all right? Rome wasn't built in a day. Just be a little patient. Let me get you a lawyer and you can tell your side to the lawyer, okay? Stop, please. All right, so what I'm going to have you do now, I'll have you sign a reset. Just take a seat in the jury box. Let me find you someone here momentarily, okay? Morning, Mr. Segundo. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On December 30th, 2024, the officer was dispatched to a possible DWI at North South Houston Tollway in Harris County, Texas. The officer made contact with a witness who stated he observed the defendant's motor vehicle fail to drive in a single lane, driving on the improved shoulder and striking the right barrier wall. The officer observed the defendant's motor vehicle change from lanes 2 to 3 without a signal, signaled the lane change from 3 to 2, and then failed to signal a lane change when going back from 3 to 2. The traffic stop was then initiated and the defendant's motor vehicle pulled over at a high rate of speed, nearly striking the barrier wall. The officer made contact with the defendant, the driver of the vehicle, and the officer observed a strong odor of an alcoholic beverage, an unstable gait as the defendant walked, and red glassy eyes. The defendant stated he was driving home from being at a party. He had consumed 3 Bud Light beers and 2 vodka mixed drinks 2 hours prior to the traffic stop. The officer administered standard field sobriety tests, HGN 6 out of 6, walk and turn 4 out of 8, 1 leg stand 2 out of 4. The defendant read the DIC and refused to provide a sample. A blood search warrant was signed and executed.
Just Segundo, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand, sir? Any prior DWIs?
No, Your Honor. And license eligible.
Okay, as long as you have a valid Texas driver license and a liability insurance, you can continue to drive. Just be careful. It may become suspended. If it does, you can't drive. You've got a lawyer. Because you do, I'll waive your appearance, but you got to stay in touch with them. They'll tell you when you have to come back to court. If they tell me they can't get a hold of you, I will revoke the bond. So just stay in contact. Don't pick up any new cases and don't use. Questions? All right, man. Good luck. Thank you. You ready? All right, let's roll, nerds.
All right, Judge, page 1, Aguilar, come on up.
You are Jose Aguilar Barrera. You speak English? Okay, toma asiento, por favor. Vamos a esperar.
All right, Judge, I can call the next one up.
Okay,
and then I'll text you. Page 11, Jackson, come on up.
you are Latoya Jackson. Ms. Jackson, you were charged with fraudulent destruction of a price tag. You are facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to, bless you. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, sir.
Okay. Good morning.
On December 30th, 2024, the officer was dispatched to a theft at a business in Harris County, Texas. Upon arrival, the officer spoke with a loss prevention officer who advised he was watching surveillance when he noticed the defendant removing price tags off items and placing them on different items in her basket. The total was $136.27. And when the officer spoke with the defendant, she admitted to removing price tags and placing them on different items before checking out.
Jackson, I'm going to find that there's probable cause to go forward with your case. Do you have the ability to hire a lawyer, ma'am? Do you work? What do you do for a living?
Healthcare.
Okay. What kind of money do you make a month? Do you have any children? Okay. Do you get support for the child? Did you want to apply for an appointed lawyer? Okay. Do you mind giving an application, please? Deputy Lopez is going to give you an application. I'll have you fill it out. I'll see. I need to know everything about you and I'll take a look to see whether you qualify. If you do, I'll provide your lawyer today, man. Please. All right. You are Aguilar Barrera.
Con palabra.
Sí, soy yo.
Yes.
Okay. Sir, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer initiated a traffic stop after observing the defendant failed to maintain a single lane and run over a curb in an underpass in Harris County, Texas. Upon contact, the officer observed unsteadiness, slurred speech, bloodshot eyes, and a strong odor of an alcoholic beverage. The defendant did not consent to standard field sobriety tests. The DIC was read, and the defendant refused a blood and breath sample. A search warrant was signed and executed.
Can you see any prior DWIs? And have you see it?
I have no license on file, and there's no prior DWIs.
Okay. Mr. Aguilar Barrera, I don't know what your immigration status is, but if you were in this country without permission and you go to jail long enough and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody until this case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months. You do not have a Texas driver license. You are not allowed to drive. Do you understand?
Sí, señor.
Yes, sir.
I don't care what's going on in your life. I don't care if you need groceries. I don't care if there's a burning building and you have to save 50 kittens. You drive, I can have a contempt hearing. I can hold you in contempt, slap you with another 6 months in jail and or a $500 fine every time you drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
Sí, lo entiendo.
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're consuming any kind of alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you. You got out of jail quick because we gave you a PR bond. If you pick up a new case or violate conditions, I will revoke your bond and you will be stuck in there for at least 6, maybe 10, maybe 12 hours. And that's when immigration will put their clutches all over you. This is the only warning you're going to get. Heed this warning. How old are you, sir? What do you do for a living? How much money do you make a month?
Como unos 3,000 a lo mejor.
All right, we're going to give you time to go hire a lawyer. So I'm going to have you come up here.
I have an attorney.
Oh, you do?
Sí, hay abogado.
Business.
Andrógeno.
Oh, and droga? Okay, so this is what we'll do. I'm going to have you swear to us you're not going to drive. I'll get you to Victoria to sign a reset. I'll have you meet with Felicia for your bond conditions, and then we'll just have you wait in back for your lawyer to arrive.
Gracias.
Please.
Thank you, sir.
All right, Judge, page 19, crawler, come on up.
You are Mr. Prowler.
Yes, sir.
Is it, did I say it right?
No.
Proler or Prol? Is it Proler?
Yes, sir.
Sir, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 30th, 2024, the officer was dispatched to a doctor's office in Harris County, Texas, in regard to a criminal trespass. The officer made contact with the complainant and the witness, and the complainant and the witness stated the defendant had an appointment at the doctor's office several hours prior, was asked to leave, and the defendant stated he was not going to leave. The officer found the defendant and the complainant, or I found the defendant and the complainant and witness pointed to him stating that that was the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
Have a lawyer, sir.
Yes, sir.
Is he coming here today? Let's do this. I'm going to hold off on it real quick. I'm going to have you take a seat. Let's wait for your lawyer to get here and then we'll.
That's exactly what he told me. He told me to just explain to you that.
Don't. Let's wait for your lawyer.
He's asked me to, or tell me to explain regarding the case itself. He simply told me to tell you he'll be here as soon as possible.
Okay, just hang tight for me, take a seat for me, and then let me know when he gets here and then we'll continue. All right, good morning, Mr. Moore.
How you doing?
Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 31st, 2024, the officer initiated a traffic stop for the defendant's vehicle speeding 61 miles per hour in a 50-mile-per-hour zone at the 6100 block of South Highway 225. The officer made contact with the defendant, driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack on the back seat of the vehicle, and the marijuana was weighed, and the weight was 2.87 ounces.
Did you say, you said speeding? Did you?
61 and a 50.
Got it. Okay.
And the issue that I have with the PC, so in regards to the speeding allegation, there were 2 cars in front of my client prior to him being stopped. It was 3 a.m. in Pasadena. He had the nicer car, was pulled over. And also my client explained to officer when he asked him about the smell in the vehicle, he did tell him that he had CBD in the car. He said that I had 3 packs. I just purchased it. They're in my backpack in a bag. They were unopened at the time. The officer did take the bag so that he wasn't, he didn't know how CBD looked or smelled. So he was just gonna find it to be marijuana and would take him in for that, even though my client did prove up the fact that it was CBD. in regards
But
to-
if it's CBD and it's unopened, it wouldn't smell, right? Because it's vacuum sealed.
Well, no, he said he smelled something in the car, but the substance that he found in the packages, they were unopened, and those were CBD. That's what he said that he found to be marijuana. But my client let him know that this is CBD, it's in my backpack. When you search, you're gonna find it, it's gonna be in there. But I purchased it earlier today from a smoke shop. And so when the officer did retrieve them out of the backpack and asked about it, he's like, well, I can't tell the difference between, what CBD and marijuana is. I only know marijuana, so I'm gonna have to take you in on that.
What form is this CBD in?
It was like in a little,
Is it,
it was a flower, so.
it is a flower?
Mhm. So I do know that the CBD flower and cannabis flower, they look very similar, so.
Your Honor, if I may, so as the DIMS establishes, so the odor was enough from the search, and finding that leafy substance is enough, because upon further testing, it may or may not, but just for the purpose of probable.
So I think for probable cause purposes, I think it's enough because the odor, right? Now, they're going to test it. If it tests different, then there we may have an issue.
Yeah.
But as far as probable cause, then you know, your record speaks for itself, Mr. Moore. Anytime you get pulled over, what's gonna happen? You know what I mean? This is what? 1, 2, 3, 4, 5, 6 marijuana case. Anytime you get pulled over with your record, what's gonna happen? Every single time. So why give them a reason? You know, really, we keep coming back and forth and back and forth and no. Can you run his license if he has?
Eligible, Your Honor.
All right, I'm not gonna put any conditions, just be careful. Don't pick up any new cases because I'm gonna lose it at that point. Just, you've got a great lawyer, listen to her, she'll take care of you. If she tells me she can't get a hold of you, I'm gonna revoke your bond. Just be good, don't pick up any new cases. If you're gonna drive, make sure you have insurance, car insurance, all right? Okay, guys.
Thank you.
Yes, ma'am.
So Judge, there was misunderstanding on the case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him to get him to come in. Couldn't get in contact with him. Then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received a letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case, because I don't know anything about it. Mr. Lestrap, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft? The prior trespass and the prior theft, can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens. Not once, but twice. What should I do now, Mr. Lestrade? What should I do? You tell me.
Judge, just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment. Has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
Yeah, it's not here home.
Did you come with mom today?
Yes, sir. Here home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat.
Yes, sir.
But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Ray, I'm sorry. I'm not going to give another PR bump. You know, perhaps, I don't know, but you're not getting it.
Can we at least address the bond, though, Judge? Because I believe the bond's at.
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today.
Yes, sir.
It goes with you. I'm with you, though.
Appreciate it.
Proceed with one alternate.
You ready? Let's roll, nerds.
All right, Judge, first is page 4. Bendy, come on up.
Hold on a second. Bear with me a second. Just go ahead, take a seat. I'm going to wait for your lawyer to get here. You have a lawyer, right?
Yes.
Okay, we'll wait for him to get here. Thanks. Okay, go on to the next.
All right, Judge, page 5. Brady, come on up.
Good morning, Mr. Brady. Mr. Brady, you are charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 1st, 2025, at approximately 12:33 a.m. at 14239 FM 2920 Tomball, Harris County, Texas, an officer observed a vehicle traveling eastbound with expired registration as of February 2024. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant, and ID'd the defendant by Texas driver's license. The officer observed the defendant to have glassy red eyes, slurred and delayed speech, the odor of alcohol upon the defendant's breath, and the defendant fumble with his wallet and pull out his credit cards when asked for his driver's license. The defendant stated he had 2 glasses of wine 1 hour prior. The officer asked the defendant to step out of the vehicle, and the defendant was unbalanced while stepping out. SFSTs were conducted. 6 out of 6 clues were observed on the HGN test. The defendant was unable to perform the walk-in turn and the one-leg stand. The DIC was read to the defendant and at Tomball City Jail, and the defendant consented to a breath specimen. The results were 0.218 and 0.208.
Any prior DWIs? Do you mind looking, please?
No criminal history, Judge.
And you ran his license, see if he has a valid license, please. Mr. Brady, I'm going to find that there's probable cause to go forward with your case. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, your bond will be revoked. You will go to jail. Do you understand?
Yes, Your Honor.
If you have a valid Texas driver license, you may continue to drive, but you must maintain liability insurance as well. If you do not have either, you are not allowed to drive. Do you understand? That is also a condition of your bond as well.
Yes, Your Honor.
Tell me, what do you do for a living?
I'm a cook, Your Honor.
Did you apply for an appointed lawyer?
Your Honor, I don't have a lawyer. I need the court to appoint one for me.
I need you to qualify though. So what I can do is I can give you an application. I'll take a look. I need to know everything about you. Just put it on the paper. I'll take a look. If you qualify, I'll give you a lawyer. Okay,
Yes, Your Honor.
please.
His driver's license is eligible.
Great. Okay, we got you. Please.
All right, Judge, next is page 10. Collins, come on up.
Is it Tyren? No,
Yes.
please. Mr. Collins, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 31st, 2024, at 2:35 p.m., an officer was dispatched to 12600 Dunlap Street, Houston, Harris County, Texas, in reference to a disturbance unknown weapon call. Upon arrival, the officer made contact with the complainant, who stated the defendant is her son and that he assaulted her. The complainant stated she lives in an apartment with her 2 sons. The complainant stated that a month ago, she asked the defendant, her eldest son, to help pay for rent, and the defendant agreed to pay a certain amount. The complainant stated she got tired of asking and told them that she was not renewing her lease. The complainant told the defendant he needed to move out by December 31st. On that day, she arrived at the apartment to turn her keys in and do a walkthrough with the complex manager, the witness. The complainant stated as she was removing the locks from the doors, the defendant pushed her with both hands and punched her in the chest with a fist, causing pain. The witness stated the defendant was acting aggressive and was refusing to leave the apartment. The witness observed the defendant push and punch the complainant.
Any dope or alcohol?
No allegations of drugs or alcohol, Judge.
Do we know what she wants?
Yes, Judge. I spoke to her yesterday and she is requesting no threatening or harassing contact and that he not be able to go near her new residence.
Got it. Okay, Mr. Collins, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your, well, let's, hold on a second, let me see. It looks like a protective order was issued on the 1st of this month. I would get to know it because if you violate this protective order, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. You violate conditions on a VPO, I can have a hearing to hold you at no bond, 0 bond, and I will do it in a heartbeat to protect my community. Do you understand?
Yes, I also had a witness too.
Stop. You will get the opportunity to fight. Now's not the time. I got a bunch of DAs here. I don't want you to say something. You'll get the opportunity. Just now's not the time. I am ordering you as a condition of your bond not to have any threatening or harassing contact with the complaining witness in this case. Understand what is threatening or harassing doesn't matter what you think. I could care less. It's what she perceives. So if I go like this, is that threatening, harassing? It most certainly is. And it can be a basis to revoke your bond. Do you understand? All right. Tell me, what do you do for a living, Mr. Collins?
I work.
Do you have enough money in that work to hire a lawyer?
No.
Tell me about what you do then.
I work as an HVAC tech.
All right, so what I can do is I can give you an application. I need you to fill it out. Don't just put zeros because I'm going to send it right back to you. I need you to fill it out. Be honest. I'll take a look, and if you qualify, then I'll give you a lawyer. I am going to file conditions that you're not having threatening or harassing contact with mom. It's mom?
Mom and Judge, the protective order says no going within 200 feet of her previous residence. She gave me her new address, so if we
Okay,
could
do you want to
add
refile it?
that. We could. Do you know how to?
Put the correct address in the MOA? You want them? Let me just, and all right, I'll print it out. We'll just amend it. I need to know, or I'll give it to you. You put the correct address.
Yes, Judge.
So, Mr. Collins, you're not allowed to go where she lives. Do you understand? If you go there, I'm going to revoke your bond. I'm going to put you in jail. You need to understand, if you don't have anyone that's going to pony up $5,000, $10,000 to get you out of jail, you'll be stuck like Chuck in there until this thing is over with. Consider that when you're out there in the free world. I'm not asking for much. Just don't become a danger to our public. Don't violate conditions. That's it. All right, Stephen, do you mind giving an application? Do you mind filing no threatening, harassing contact and no weapons?
All right, Judge, next is
I need to give it to them.
page 12, Spanish speaker, Diaz Jimenez.
Good morning, Mr. Diaz Jimenez.
Good morning, Your Honor.
Oh,
I
he's-
understand English.
Okay, so do we want to do him later and we'll do the other Spanish speaker since we have Blossom? All right, just take a seat for me momentarily. We'll help you out here momentarily.
All right,
Sorry,
Judge,
thanks,
next
guys.
is a
Thank you.
Dela Cruz, come on up. On page 11.
Good morning, Ms. Dela Cruz. Ma'am, you were charged with unlawful carrying of a weapon in a public place. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay, guys, please.
Your Honor, on December 31st at approximately 11:37 p.m., officer was dispatched to a weapons disturbance at 1111 Grove Street, apartment 1111 Houston, Texas. We informed the officer, the witness informed the officer that she was outside and heard a gunshot and looked to the left and saw defendant, witness's neighbor, waving a gun in the air toward the kids in the playground and towards witness's group. Witness stated that defendant left location and returned yelling and waving the gun in the air and pointing it all around the apartment. We recorded the interaction. Witness recorded the interaction with the defendant pointing the gun and trying to shoot it, but nothing came out at the time. Another witness informed the officer that she heard a shotgun shot and observed defendant waving gun toward a basketball court and park where there were kids. Defendant then ran into the house. A third witness corroborated both accounts. Witness number 3 also recorded the incident. Defendant was ID'd by eyewitnesses and a mugshot. Defendant was found sitting on a porch and observed the officer.
Strong odor of alcohol.
Observed a strong odor of alcohol.
Okay.
And the
Is
officer found a
this-
case. of
So
breath.
AB, is that what it says?
Yes, Judge.
Strong odor of alcohol in her breath.
Yes, Your Honor.
So did she actually get a shot off? Did you have, do
Judge, the officer found a casing in front of her apartment.
you have anyone that saw them?
Nobody that physically saw her get the shot off, just they heard the shot and then they saw her waving the gun around after that point.
Ms. De La Cruz, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs or alcohol, you better address it, because if you don't, I'm going to do it, and you're not going to like the way that I do it, ma'am. Stop. I don't want you to say anything. I'm just telling you what the expectation is here. I'm going to protect my community at all costs. I don't care what happens, with who it is, what color, small farm animal. I don't care. I'm going to protect my community. You're not to be in possession of any weapons as well. If I find that you have a weapon, likewise, I'm going to revoke your bond, put you in jail, and I'm going to raise the bond. I'm not asking for much. Tell me what you do for a living, ma'am. Do you have the ability to hire a lawyer?
Right now,
Do you have the ability to hire a lawyer?
well, somewhat if I need to, but I wanted to ask for a court appointed at first.
So let's do this. I can give you an application to fill out. I'll take a look, and if you qualify, I'll provide you a lawyer. But I need to know everything about you, and just fill it out honestly. Well, you don't have to tell me, just put it on there. I need numbers though. Give me numbers. I'll take a look, and if you qualify, I'll provide you a lawyer. You're gonna meet with Felicia for your bond conditions. No, Felicia, for your bond conditions, no alcohol. Do you understand, ma'am? No weapons. That's all I'm asking you to do, and don't pick up a new case. Okay, Stephen, please.
Judge, was that pretrial bond conditions? or-
Yeah, with Felicia. No, we're gonna monitor, make sure she's not using.
Next judge is.
Hold on, hold on, hold on. Do you have an arraignment?
Yes, page
Okay.
18.
All right. You ready? Come up, Ms. Strong.
Randrum, come on up.
How are you? Great to see you. What's new? Happy New Year. Please tell me, Rabbi. Hello. Good morning, Ms. Landrum. Ma'am, you are charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay. Hi, Alex.
On December 21st, 2024, the officer was dispatched to a major accident on East Freeway in Harris County, Texas. The officer made contact with the complainant. The complainant stated he was traveling in lane 2 out of 4, observed in his rearview mirror the defendant's vehicle traveling at a high rate of speed, following closely with a motorcycle also traveling at a high rate of speed. The complainant stated the defendant was racing with the motorcycle. The defendant was mimicking the motorcycle's lane changes in speed. And when the defendant entered lane 1, the defendant began to lose control, and her front bumper collided with the complainant's front right, causing him to lose control and crash into another motor vehicle. A total of 4 motor vehicles were involved in the collision. All vehicles were towed, and the damage for each vehicle was over approximately $1,000. The officer made contact with the defendant, who identified herself as the driver of the vehicle.
What does high rate of speed mean?
Let me see if the officer specified.
I mean, I'm gonna find probable cause, but I'm curious. I mean, if she's going just while he's doing that, Miss Landrum, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive like this again. And if I find that you're driving like this, or you pick up a new case, I will take your ability to drive away. And I'm gonna tell you, living in a city as big as Houston without the ability to drive blows. It's awful. Try living without driving. It's terrible. So just don't, please.
Your Honor, the speed's not specified in the OR.
I mean, I think that there's enough to go now for probable cause. Just be careful. You've got a great lawyer. She will take care of you. You must listen to her. Because you have a lawyer, I will waive your appearance, but you have to stay in touch with her. If she tells me she can't get a hold of you because you're playing games, I'm gonna issue a warrant for your arrest. Don't pick up a new case and not on 610, all right? We're gonna craft bond condition for you to sign. Once you sign them, after that, you'll be free to go, okay? All right, thanks, Mr. Johnson. Just no reckless driving, racing, you know, donuts, street takeovers and the like that.
Thank you.
Just- Okay,
Thank you.
please.
Right this way.
No driving like Batman.
All right, Judge, next is page 12.
Oh,
Diaz,
Thank you.
come on up.
so can you file those conditions? Do you
Yes,
mind,
Judge.
please? You are Diaz Jimenez, correct?
Yes, Your Honor.
Mr. Diaz Jimenez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 1st, 2025, the officer observed a vehicle on the 19700 block of US Freeway 59 make a last-minute lane change and cross a solid white line. Once in the lane, the vehicle failed to maintain a single lane and touched the white line multiple times. When the vehicle came to a red light, the vehicle stopped much slower than prudent and slowly inched up to the stop line. Once at the stop line, the vehicle proceeded past the stop line with the entire vehicle nearly past the line and in the intersection. The vehicle then accelerated through the red light, running the red light, and a traffic stop was then initiated. The vehicle failed to maintain a single lane multiple times before stopping, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed the defendant to have an odor of an alcoholic beverage, slurred speech, and red, glossy, bloodshot eyes. The officer asked if the defendant had any alcohol to drink, and the defendant became belligerent and refused to answer. The officer observed a strong odor of an alcoholic beverage, and the defendant agreed to perform standard field sobriety tests, but walked away and refused. Based on training experience, the officer believed they lost the use of mental faculties and physical faculties, and the DICs were read. However, the defendant refused breath specimens. A blood search warrant was signed and executed.
Got it. Any priority to be eyes? Can you check, please?
There was a prior in 2017, Your Honor.
Out of Oregon, Judge.
Okay. Mr. Diaz, I'm going to find that there's probable cause to go forward with the case. I am now placed, can you run his license, please?
Yes, Judge.
I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I'm going to put you in jail by revoking your bond and raising it. Do you understand?
Yes, Your Honor.
We don't have a license on file, Your Honor.
If you do not have a license, you are not allowed to drive, and I'll have you sign an affidavit with me today promising me you're not going to drive. I don't care if there's a burning building and you have to save 50 children. If you don't have a license and a guardian interlock on your car, you are not allowed to drive. Do you understand?
Yes, I understand.
You will be randomly tested also to prove, so that we know that you're not consuming any kind of other substances as well. Tell me, Mr. Diaz Jimenez, do you have the ability to hire a lawyer? Okay, if you ever have any issues, come back and we can talk about giving you an application for an appointed lawyer. But I'm absolutely serious when I'm telling you I'm going to protect my public at all costs. Every single day, there's a death in Harris County due to alcohol. You understand? All right, I'm gonna have you come up here, swear to us. I'll get you to Victoria to sign a reset. You'll get with Maddie for your bond conditions. Then after that, you'll be free to go. Please. Say it again.
Page 2, Angel.
Good morning, Miss Angel. Ma'am, you are charged with theft of service. You're facing up to 6 months in jail and or a $2,000 fine. Do you have a lawyer today, ma'am? Let's do this. I'll provide you one today. Let me have you take a seat in the jury box and we'll see where we go. Your case is extremely old and I don't know where we're going to go from here. So let's do this. I'm going to have you provide your lawyer today. We'll have you talk to them and we'll go from there. Just take a seat for me in the jury box, please. Thanks. Roberto Castillo, come up.
I've been in Montgomery County this morning, that's why I'm so late.
That's okay. You're not late. Good morning, Mr. Castillo. Sir, you stand charged with the offense of driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
So on January 1st, 2025, at approximately 4 a.m., the officer observed a vehicle traveling eastbound on FM 2920 in Harris County, Texas. The vehicle pulled into a parking lot and then exited the parking lot onto another roadway in an attempt to avoid the officer's patrol vehicle. The officer initiated a traffic stop on Tomball Parkway, and upon contact with the defendant, the driver and sole occupant of the vehicle, the officer observed glossy red eyes, slurred speech, odor of alcoholic beverage, and the defendant stated he had a six-pack of beer approximately 4 hours prior. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused breath. A blood search warrant was signed and executed.
What was the stop for?
Allow me to read the DIMS, Your Honor, to see if he specified. So according to the officer, the vehicle pulled into a parking lot and then exited in an attempt to navigate away, and the vehicle crossed through the parking lot onto another roadway. And that appears to be all the officer put in the DIMS.
Tell me what he did wrong. What code, what transportation code has he violated? What ordinance, statute? Give me something. I mean, I can give you a little bit of time if you
Give us some more
want.
time, Your Honor, so I can look at
Can you
this.
give me 5-10 minutes, Owen?
Sorry, Judge, I have other cases in buildings.
Okay.
I agree with the court.
I don't-
Even if they allege that he was attempting to, if he cut across, there is a violation for cutting across in order to avoid a traffic control device, but they didn't allege that. All they've got is him turning into a parking lot and then back onto another street. So that's not a law violation.
Like 10 minutes and we can.
Yep, go to it.
Thank you.
All right. Just take a seat. Don't leave. And then when you come back, we'll finish.
Page 19, Lopez, come on up.
Good morning, Mr. Lopez. Sir, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 31st, 2024, an officer was dispatched to HEB in Harris County, Texas regarding a shoplift that had just occurred. The officer made contact with the complainant. The complainant is the manager of the HEB and observed the defendant Diaz and defendant Lopez walk through selecting merchandise and place items inside of a red HEB bag and communicate with one another and place items inside backpacks they came inside the store with and roll up the red HEB bag and place it on the bottom rack of the cart. Defendant Lopez paid for 3 items left in the cart. Defendant Diaz went inside the bathroom and reemerged after defendant Lopez paid for the items. Neither defendant attempted to pay for the items in the backpacks or the red HEB bag. The complainant locked the produce exit doors and attempted to confront the defendants. The defendants split up with respective backpacks. Defendant Lopez carried the red HEB bag and the defendants ran from the store management and security in opposite directions. Defendant Lopez was identified by his name and date of birth.
Okay. Mr. Lopez, I'm going to find that there's probable cause to go forward with your case. The co-defendant is the co-defendant in our court.
We had him last week.
He's in here? Okay. I'm ordering you as a condition of your bond not to go to any HEB. Do you understand? If I find that you go to any HEB, if I find that you pick up a new case, if I find you have contact with the co-defendant, I'm going to revoke the bond, put you in jail. No more PR bonds. Do you understand? What do you do for a living, sir?
Currently looking for a job. Yeah.
I'll have you fill out an application for an appointed lawyer. I am ordering you as a condition of your bond not to consume alcohol or illegal drugs as well. If I find that you're using, it's not going to go well. Do you understand? All right. I already have an application on file. I'm going to have you take a seat in the jury box. We're going to try to find your lawyer here momentarily, Mr. Lopez.
Right this way.
Or Mr. Lopez, I need you to sign a reset first.
What inside?
I'm back on Mr. Castillo, PC here.
All right.
Yes, Judge. So in
Enlighten
regard
me.
to the crossing the parking lot, it was the officer's understanding, I spoke with the officer, that crossing the parking lot is a violation because he crossed right through, and the traffic code that we found is transportation code.
Hold on. Did you take a look at this?
Judge, I'm very familiar with the statute they're quoting.
Okay, what is it?
It's section 545.423. And it's crossing property, and it states that an operator may not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle. And the officer said that he crossed, according to the DMs, he crossed straight through onto the public roadway. And speaking with the officer, he repeated that as well, saying that he was at a slow roll and he just went straight through upon noticing the officer. And that's whenever he performed the traffic stop, as he crossed that parking lot.
An operator may not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle.
Yes, Judge. And as
He
the,
never stopped at all.
correct, and as the DIMS states, the vehicle pulled into the parking lot and exited the parking lot in an attempt to navigate away from the patrol vehicle. So he just entered and exited. He didn't stop.
First, Judge, that statute requires that you're doing it for the purpose of avoiding the traffic control device. There's an additional element.
Really?
Yes, Judge, if you look at the statute.
Hold on. There's only, it says, so that what I read was A. B says an operator may not cross or drive in or on a sidewalk, driveway, parking lot, residence, or residential entrance at an intersection to turn right or left from one highway to another highway.
In order to avoid the traffic control device.
Correct, but that looks like it's an or, not and. Or, you know, unless you show me, unless you can show me differently, I mean.
It is an or, Judge. I agree with that. However, may I address another issue?
Of course.
If you listen to the DIM summary, he says he intended to stop my client to begin with. Then my client, in order to evade him, rolled across the parking lot. There's no explanation as to why he started attempting to stop my client in the first place. I recognize, of course, that police have many and multifarious functions, but activating emergency lights and attempting to stop somebody for some unexplained reason.
I didn't hear that.
Well, Your Honor, the DIMS reads,
it's certainly interesting.
It reads different because it says while the officer was patrolling, he observed the vehicle, and it immediately goes into how the vehicle pulled into the parking lot and exited in an attempt to navigate away from the officer's patrol vehicle. And after that point, it says the officer initiated his patrol lights. So he wasn't attempting to stop him at the point that he entered the parking lot. All the officer articulated was that he was attempting to navigate away from his vehicle.
I mean, what it sounds like to me is he sees the officer and just tries to get away. And then the officer sees him do something that's maybe a violation of the transportation code and pulls him over right there. Had he kept driving and just gone straight, perhaps it would have never been pulled over. But the virtue of the fact that you go and do that, you know, if there wasn't a violation, I would kick it all day. But I mean, they, you know.
May I address one other shortly, very shortly?
Please.
The way he says in his DIM summary, he says, the purpose for crossing is to evade me. He is thinking this man is trying to evade me. And that certainly implies that he was trying to stop the defendant before the defendant started and turned into the parking lot. Otherwise, why would he say he was trying to evade me? In other words, if he's consciously thinking this man is evading me, he's doing something that would lead the defendant to evade.
I agree with you.
So without showing as why.
I agree with you. But the fact remains is he went through. And it looks like he may have indeed violated that part of the transportation code. Now, pull the video. If the video shows you something differently, come back and we can do PC again. You know, I'm always happy to revisit it, but perhaps if he would have kept going and not done anything, not done that, he wouldn't have gotten pulled over. If he would have and nothing had done, there had been no errors, then you know what would have happened.
Understood.
I'm going to find probable cause for now. What was the last name again?
Castillo.
Castillo.
Roberto Castillo.
Okay, Mr. Castillo, I'm going to find probable cause. And let me tell you, you speak English, right?
Sir.
And by no means does this mean that you're guilty of this offense. This just means that there's enough to go forward now. That's all it means. You got a great lawyer who will handle the case for you. If there are always any issues, you guys can come back and reapproach and we can go from there. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond. Okay. As long as you have a valid Texas driver license and liability insurance, you may continue to drive.
It's eligible, Your Honor.
Great. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but just stay in contact with Owen. He will tell you when you have to come back to court. If Owen tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Do you understand?
Yes, sir.
Okay. For now, I'm going to have you sign your receipt. Victoria will have you get with Maddie for your bond conditions, and then you guys are free to go. Thanks. Of course.
All right, Judge, page 33 and 34, White, come on up.
I should be attached.
Did you already file it?
We did. I talked to him. It was attached
Peter?
this morning. Good morning, Judge.
How are you?
I am doing well, I think.
Good to see you, like always.
Good to see you too. I saw you yesterday.
2 days in a row. Fabulous. Who is this gentleman? Mr. White.
Page
So, new case.
33 and 34.
All right. Good morning, Mr. White.
Sir.
Sir, you stand charged with two offenses. You're charged with driving while intoxicated. Second offense, you're also charged with failure to stop and give information. On the DWI, you're facing up to a year in jail and or a $4,000 fine. On your other case, you're facing up to 6 months in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 1st, 2025, officers were dispatched to a major crash at the intersection of Westheimer and Synod Street. Officer made contact with the complainant. The complainant stated she was driving and she was at the intersection when the light was green. She proceeded through the intersection, saw the defendant's vehicle run a red light at a high rate of speed, and the defendant's vehicle was struck by the complainant. The damage to the complainant's vehicle was approximately $9,000. The complainant stated she was never contacted by the defendant to exchange information. The officer made contact with the defendant and observed glossy eyes, slurred speech, a moderate odor of an alcoholic beverage, and unsteady balance. The officer also observed swaying and disorientation. The defendant stated he was driving his motor vehicle when the other motor vehicle struck his, that he was the sole occupant of his vehicle, and that he was driving the damaged motor vehicle that the officers observed on scene. The defendant admitted to consuming alcoholic beverages prior to operating his motor vehicle, that he was coming from a steakhouse and was on his way to his friend's home to sleep, that he had drank 3 bottles of beer at a gas station across the street from the scene, and that the defendant stated he did not consume illegal drugs that night. He also stated he was unsure of which street he was on and rated his intoxication as a 5 from a scale of 1 to 10. The defendant stated he parked his motor vehicle, was going to walk to an apartment complex where the officer stopped him to tell his friends to call the police, and that he could have called the police given that the officers observed the defendant's phone on him. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 4 out of 8, 1 leg stand 3 out of 4. The defendant was read the DIC and refused. A blood search warrant was signed and executed.
Did you want to say something?
I did, Judge. I'm not sure about the quote, but I'd like to hear a little bit more about leaving the scene. It sounds like
I didn't hear
I
anything.
didn't hear anything on PC.
You didn't say anything about the FSGI.
So on the FSGI, the complainant stated she was never contacted to exchange information. After, and then also furthermore, I can read from the complainant.
He stayed there, right?
No, Your Honor. So allow me to read from the full.
You got to leave.
So he was found at a gas complex where apartment complex where he was stopped, and that's where he made contact with the officers. And the full DIMS I can elucidate
Okay,
that.
so he wasn't
at the
scene of the accident.
No, Your Honor. He was later found at an apartment complex. That's where he was stopped, and he told the officers that he could have called police because they observed the phone on him.
Did he say how far?
Let me see the DIMS if I can see.
And Judge, he's bonded on both cases. I mean, there's plenty of room for us to negotiate and work with the state on this. I mean, it may very well be.
I just want to make sure that, if he's charged with an offense, there's enough probable cause. And, From,
Tim's is about 5 pages long.
Yeah, it doesn't look like it. They say the distance, just that they made contact with him at the apartment.
where? At the apartment or?
There's an apartment complex where they stopped him. That was not the scene, and that's where they found him, and they saw him with his phone on him, and that's where they made contact and asked him if he could have called police. And he said he could have, and that he was walking to that apartment to get his friend to call the police.
And Judge, we have both locations of where the crash occurred and where he was found. If you could give me a moment, I can get the exact distance.
If that's the case.
I have a lot of problems here.
I have an identification question then, if that's the.
I have, he goes to the gas station, he's drinking at the gas station. You know,
Yes, Judge, and because he did state he drank at the gas station across from the scene, and then
do we know if he started drinking after the accident, before the accident? Did the officer ask?
well, he did state that he drank prior to the accident because he was at a steakhouse, is what he said.
You have no distance on as far as where he was from.
Locations, and we can find the distance. If you just give us a moment, we can see how far the two locations are.
Well, I am gonna go forward with your, I'm gonna find that there's enough probable cause to go forward on the driving while intoxicated. Does he, have you run his license, see if he has a valid Texas driver license?
Yes, Judge, his license is eligible.
Okay, I'm now placing a restriction on your license, Mr. White. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I'm going to revoke your bond. I will put you in jail. I am ordering you also as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If we find that you're consuming alcohol or any illegal drugs, likewise, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court, but you must stay in touch with Mr. DeLeaf, and he'll tell you when you have to come back to court. If Peter tells me that he can't get a hold of you because you're playing games, then I will again issue a warrant for your arrest.
Your Honor, so it's 0.3 miles, and furthermore, upon reading the OR, there were bystanders on the scene that told the officers that they identified him as walking towards the apartment complex and failing to give information from the crash. So we have 0.3 miles, and a bystander saw him walking from the scene of the crash towards the apartment complex.
I will now, I'm going to find probable cause for now.
Okay,
Peter,
for
if
now-
you- if you find something that's different later on, come
Okay,
back, we
fine.
can always talk. You are also not allowed to drive unless you have liability insurance in your name on whatever car you're driving. We are sending notice now to DPS that you're required to have an interlock. So every officer in this state is going to know if you're caught driving a vehicle and it doesn't have an interlock, they're going to take you to jail. Do you understand? Okay, so I'll have you sign reset with Victoria. We'll have you get with Fleischer for your bond conditions, and after that, you're free to go. Okay, guys.
Appreciate
Take
it.
care.
William, Gerard, come up.
Mr. Williams, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 29th, 2024, the officer is dispatched to a disturbance involving a weapon at an apartment in Harris County, Texas. The officer made contact with the complainant, who stated she and the defendant are in a dating relationship, that she left the club with a witness, and she received a call from the defendant asking where she was at. The defendant was upset because she was not at the apartment when he was there, and the defendant was texting her that she better not be at the apartment, and that would be her best bet once he got to the apartment and she was not there. The defendant was texting her, but the complainant stated that when she returned to the apartment, she observed the defendant walking towards the motor vehicle she was in with a black metal object in her hand, banging on the window of the motor vehicle. And the defendant told the complainant to get out of the motor vehicle or he was going to drag her ass out. The complainant felt threatened and called the officer. The defendant sent text messages to the complainant reading, "It's cool because whenever I catch you, I promise you on my life, bitch, I'm going to show you. You think I'm bullshitting? Let that bum ass have you made for each other on my mama. So I'm telling you to stay where you at. But for real, whenever you come here, bitch, you better have backup because I'm going to drag you, bitch."
Mr. Williams, there is probable cause to go forward. I'm ordering you as a condition of your bond not to have any contact with this complaining witness and not to be in possession of weapons. Do you understand? There is a protective order that has been issued in this case. Get to know it, because if you violate the protective order, the state can file a violation of protective order against you, and it's one of the worst cases you can pick up. You understand? We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. We'll have you take your seat in the jury box. So we'll get your bond conditions. We'll have you sign it. And then you'll be free to go.
I had came to court when I was, and they had appointed me in court.
That was for probable cause court, but it doesn't.
To be able to have a, well, he had found me entered it to be able to have a court appointed lawyer.
I have a financial affidavit here that says that you make nearly $8,000 a month.
Well, I'm not at work. I'm not gonna be able to go to work until this case is over. So I've been out of work since October.
All right, so let's do this. I'll have you fill out a new one. Just put all the information on it. I'll file it, and then assuming you do, I'll give you a lawyer today. Okay? But I need you to fill out another one. I cannot give you a lawyer when I have an affidavit that says that you make that much. So I need to know the true number. No. Let's not talk about the case now.
No, it's not about a case. It's about me going to work. I have my.
Let's do this. Hold on. I don't want you to say anything where just, let me have you look. Let me have you do this. If you qualify, I'll give you a lawyer. Talk to the lawyer. The lawyer can come talk to me. Okay? All right, please.
All right, Judge, the second arraignment is the printout that's on the side there. Go ahead and sign it.
Neela?
Yes. Come on up.
Okay, Your Honor, Williams bond conditions, no contact, no weapons. Please, yes, Judge.
Good morning, Mr. Neela. Sir, you are charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
One moment, Your Honor.
Take your time. No rush.
Okay. On January 5th, 2025, the officer observed the defendant's vehicle at the 8400 block of Katy Freeway approach from the rear at 107 miles per hour in a 60-mile-per-hour zone and passed the patrol motor vehicle. The officer caught up to the defendant's vehicle and observed the vehicle to be traveling 118 miles per hour in the 60-mile-per-hour zone, along with cutting multiple vehicles off and almost striking one motor vehicle. A traffic stop was conducted and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The defendant stated he was just going with the flow of traffic.
Mr. Neal, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you not to drive any vehicle whatsoever. Do you understand? You will be signing an affidavit with me today, promising me you're not going to drive. And if you do, you can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? If you would like, I can have you fill out an application or an appointed lawyer, and I can see whether you qualify to have you talk with someone today. Would you like to do that? Okay. Do you mind giving an application? I'll give you an application. I need to know everything about you, how much money you make, how much money you spend, how much money you have in the bank. I'll take a look to see if you qualify. If you do, I'll provide you a lawyer today. Mr. Johnson, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with terroristic threat of a family or household member. On both of those cases, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I see that your bonds are pretty high. They're both at $50,000 now. I don't know why, but let's find out.
On November 17th, 2024, Texas, the complainant witness made a report that the defendant had assaulted her that day. The complainant witness stated that the defendant had been dating for 3 months and broke up. That day, the defendant went through the complainant witness's phone and found some messages between the defendant's cousin and the complainant witness, causing the defendant to become angry. The defendant then accused the complainant witness of sleeping with the defendant's cousin and cornered the complainant witness before pushing her against the wall and throwing her to the floor. The defendant then punched the complainant witness in the head 5 times and kicked her in the stomach, causing pain. So that's the assault in November, and then the terroristic threat in January, on January 7th, 2025 in Harris County, Texas. Officers were dispatched to a disturbance call Officers arrived and made contact with the complaining witness, who stated that the defendant is her ex-boyfriend, and he came over to her home and stated, quote, "You are playing with my life. I'm going to kill you. I'm going to show you," end quote. Complaining witness stated that the defendant then stated, "Your baby daddy will be dead and you. I'm going to smoke you both." The complaining witness stated that she feared that the defendant would carry through with this threat. Officers called the defendant. He had who acknowledged that he had several warrants relating to the complaining witness.
Is the ag assault same complaining witness? Really?
Yes.
That's a new case? Or
3 separate dates, same complaining witness.
Thank you.
And on the
ag assault, what happened there?
ag assault, let me see, Judge. All right, the complaining witness is the ex-girlfriend of the defendant. She arrived home on July 22nd, 2024, and found the door to her apartment had been kicked in and the defendant was there waiting for her. The defendant began arguing with the complaining witness about the way she was dressed. The complaining witness told him to leave, and the defendant then stabbed the complainant in the leg with a pocket knife, leaving an approximately 1-inch hole in her leg.
He stabbed her?
No.
Allegedly.
Yeah, thank you.
Stop.
The witness recovered the knife used to stab her, and then pursued the defendant in her vehicle. She also acknowledged attempting to run the defendant over.
All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with your cases. I'm issuing a order. Well, let me see if the order of protection has already been issued. I'm issuing what's called a magistrate order for emergency protection that identifies the complaining witness in this case as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within. I'm going to do 1,000 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this, it's very possible they file a violation of protective order. It's one of the worst cases you can pick up. You violate conditions on a BPO, we can have a hearing to hold you at 0 bond, and I'm going to do it in a heartbeat to protect every person in my community. Do you understand?
Yes, sir.
Can you file no contact and no weapons?
Yes.
I don't know if you're going to get out, but if you do get out, I'm ordering you to remain under house arrest, and I'm going to put a monitor on your ankle so I know where exactly you are at all times. Do you understand? You're not to use alcohol, any kind of illegal substances. Okay. Did you want to add anything?
Yes, Judge. My client was, I'm getting from my client, Judge. If you want, we lower the bond. We opposed to lower the bond. My client works. He's opposed to his 13-year-old daughter, and those are factual issues. Okay, I'm gonna let him have the floor. Yes, Judge.
No, because you know what? I just don't want you to say something. The only thing I know is that you have an open felony evading. You're on probation for felon in possession of a weapon. You pick up an assault family member in November, an aggravated assault where it's an alleged stabbing, and now a terroristic threat. So you were literally out
Judge, that's from the
all
same,
this, and now you've picked up.
That's from the same girl. She lying. I got screenshots and everything showing she lying. Why the same girl had me coming to your house if I'm stabbing?
And look,
sense.
Evidence.
I mean, I'm a fugitive in your house then. So why you didn't call the police if I'm a fugitive laying in your house? This case been over. I've been in your house and they picked me up from your house the other day. It's the same girl. She be lying. I got screenshots. She threatening, trying to blackmail me and everything. I'm not gonna stab no girl. I'm 31 years old. Never had these cases.
Evidence will point to whose side is correct.
I got everything. That's why I just want her to know that you own me like I'm really doing it. Like I'm not doing this to no girl.
It's over and it's over and it's over.
That's what I'm
You
trying
got
to show you.
5 open cases, man.
So I'm talking about the thing. I'm just showing you. This dude may come and say, I stabbed you. And I've been having to
I don't
open
care.
the warrant. I
That's-
didn't call the police to come pick me up. Why I'm in your house?
Mr. Johnson,
All right.
I'm not
Yes, sir.
going with that here.
Okay, I understand.
The only thing I'm telling you is that you want me to reduce the bond.
I apologize. I'm just saying it's just eating me up for you to really believe I'm a stabber. Girl, I'm 31 years old, never had these cases till I deal with this girl.
Those are factual issues.
I'm telling you what.
Just understand that if you do get out,
I don't want to.
you got these bond conditions.
Some she come to my mama's house, she go to jail.
I advise my client that's something that he would have to handle outside of this court.
Cause she'll come to my mama's house. She is crazy.
The only thing I would say is that when you're out in your house, when you're out where you are, and she comes to you, Don't even answer the door. Don't even go to the door and call the cops. That's all you got to
Hey,
do.
man, I got screen. I'm gonna get everything
You
printed out
know,
for y'all.
but
Okay.
just, you know,
Yes, ma'am. Yes, ma'am.
Mr. Johnson, in life, there are certain people who are a cancer to you. And if you don't cut them out of your life.
For sure, that's what I'm
What
doing
I
right
mean-
now. That's why I'm gonna get this out the way. I'm gonna get the screenshots, everything shown, everything, and get this out the way, bro.
We're good.
Yes, sir.
I need him to sign the conditions. I don't know if I'm going to reduce the bond, you know, let's do this. He's being held at no bond right now on all the felonies as it is. If that changes, come back and we can talk. Okay, but right now he's being held at no bond on all these felony cases as it is. So if and when that does change, come back.
50, 20. They gave me $250,000 bond and a 20 on the felonies.
I see on the ag assault, on the evading, it's at no bond. Right? On Mr. Johnson?
I'm just gonna get my mom, get the phone, get the neighbors, ring cameras, and for the neighbors.
Those are facts that we cannot fight.
Oh, yeah, it's over with. That's why I'm ready to go so I can get all my stuff done for the big court.
So I guess let's do this. Let's set it off a week to see what happens in felony court, and then you guys can come back and we go from there. All right?
So
I need him to sign conditions though, so he needs to sign with.
And that's for y'all court too, man, but this ain't true. All right, let's do it.
All right. Good morning, sir. Sir, you were charged with the offense of assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
All right, on December 26, 2024, an officer was dispatched to a assault report. Officer made contact with the complainant witness who stated that her husband and her had been in a heated verbal exchange over her possibly having an affair. According to the complainant, the defendant was intoxicated and got angry when she began engaging in the argument about infidelity that were found on his cell phone. The complainant stated that the defendant then slapped her on both sides of her face multiple times, which caused pain to her head, and that she was also pushed to the ground, which resulted in her receiving an abrasion to her right knee. The complainant stated that she was able to stop the defendant from assaulting her further by using a baseball bat. The complainant had visible injuries to both sides of her face and her right knee.
Mr. Capatillo, I'm going to find that there's probable cause to go forward with your case. I am ordering you as a condition of your bond not to have any contact with the complaining witness in this case.
Can we address that, Your Honor? The state, we've spoken about this, the state reached out to complain and we're in agreement for no threatening, harassing contact. They have 4 kids together. She has no issue with him living in.
I just spoke with her and she wants him back home, so.
Can I say something, Your Honor?
No, it's just now's not the time. Did she go to him with a baseball bat? Is that what you were saying?
Judging the dims, it indicates that she had I'm not sure what she did with the baseball bat. She said, it says using a baseball bat to defend herself at the very end there. I'm not sure if we have a.
Scares me.
I'm not sure if we have we don't have an OR judge. That's all the facts that I have right now on that.
How long ago was this?
This was about 2 weeks ago.
And they're living together. He's supporting his whole family. They have 4 kids together. He needs to be able to stay home, provide, and be able to help his wife with just taking care of his large family. No assaultive history, right? No assaultive history at all, Your Honor. One of his sons is also autistic, Your Honor, so they really do need help.
Mr. Capatillo, you are not to use, consume alcohol or illegal drugs, and I'm going to test you like crazy to make sure that you're not using. If I find that you use, I'm going to put you in jail. I will revoke your bond and I'm going to raise it up. Do you understand?
Yes, sir.
I will reluctantly allow you to have contact with this person, but I am ordering you not to have any threatening or harassing contact. You need to understand that what is threatening or harassing doesn't matter what you think it is. It's what the other person perceives. So if I go like this, is that threatening or harassing? It most certainly is, and it can land you in jail. Do you understand?
Yes, Your Honor.
I realize that times may be tough. I realize you may have stressful situations in this life, but you need to find some kind of outlet for it. Because if I find any other issues, I'm going to protect my community at all costs for all. Do you understand?
Yes, sir, I do.
And Your Honor, requesting a $500 PR bond.
I am entering what's called a mattress order for emergency protection that identifies her as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go. This comes with a residential restriction. I will take it off for now. But if I find there are any other issues, you know exactly what's going to happen. No consuming alcohol or illegal drugs from any source. Do you understand?
Yes, Your Honor.
What do you say? PR bond.
Judge, I don't believe that a PR bond is necessarily appropriate in this case based on the allegations and the fact that, you know, the officer is indicating visible injuries to the complainant. We believe somewhere in the range of a $3,000 surety bond would be more appropriate.
Your Honor, my client's a U.S. citizen. He's taking care of his family. He's in court today. He has no kind of assaultive history. He has a good job. We feel that a PR bond would be appropriate at this time.
Any other prior assaults or assaultive history that you see?
History is,
As
criminal
NCIC?
history is from back in 2009, the last time he picked up anything, and it was a DWI.
Okay. Mr. Capatillo, I will give you a PR bond today, but I'm going to tell you, it's the only one that you get. If you pick up a new case, you start acting a fool out there in the free world, I will take the free world away from you, lickety split. You understand?
Yes, Your Honor.
All right. What did you say as far as the bond amount?
As for-
Three?
As for 500, Your Honor.
I request 3.
Okay, so I'll split it, 2,000. So you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games and not responding to phone calls, text messages, I will issue a warrant for your arrest. If you pick up a new case, violate any of the conditions, a warrant will be issued. Do you understand?
Yes, Your Honor.
If you ever have any questions, all you have to do is come back here and we can also answer any questions that you have, any issues that you may have, but don't just start doing stuff on your own.
Agreed, Your
We
Honor.
good?
Yes, sir.
Okay.
Thank you, Your Honor. May I be excused?
Yeah, but he can't leave until he signs. Okay.
Judge, did you need me to file anything on that one?
No, because he's going to be monitored because of the alcohol. Okay, you ready? Hi. All right, you ready? Let's roll.
All right, Judge, page
Nerds.
1, Barragan, Lopez, Jorge, come on up.
Do you know if they're going to be here?
Yes, I will.
Did they know, you know what time? If you want to wait, we can wait a little bit. I'm fine with that. Yeah, just let them take a seat. We'll come back, please.
All right, Judge, next is page 1, Benedict, come on up.
Chelsea Benedict. Ms. Benedict, you were charged with assault causing bodily injury. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On January 2nd, 2025, the officer made contact with the complainant, a Walmart asset protection employee, who stated he was contacted by other staff members about the defendant attempting to enter the employee-only section of the store. The complainant confronted the defendant, and the defendant presented manifestly under the influence of an intoxicant, and the defendant was asked to leave. The defendant refused, and the complainant blocked the defendant's entry into the employees-only section, and the defendant then punched the complainant 4 times in the chest with a closed fist, causing pain.
All right. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. No more PR bonds. Do you understand, ma'am? Where was this?
It was at a Walmart, Your Honor.
Okay, you are not allowed to go to any Walmarts. Do you understand that is also a condition of your bond? If you violate any of these conditions, you pick up a new case, I will revoke your bond, put you in jail, and are you employed at this time?
No, I have a job interview tomorrow.
Did you want to apply for an appointed lawyer?
Yes.
Okay. I already have an application on file. So what I'm going to have you do is I'm going to have you go to Victoria Center Reset. I'm going to have you get with Fleischer for your bond conditions. We'll have you take a seat in the jury box while we find your lawyer. Okay? Please,
Judge, no contact with the complainant is right this way.
please, and no weapons.
Yes, Judge. All right, Judge, next is page 2. Voice, there.
Was that right, Bourgeois?
Yes, sir.
Ma'am, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 2nd, 2025, officers were dispatched to a trespasser call at a McDonald's in Harris County, Texas. The complainant, the manager of the McDonald's, stated the defendant had been asked to leave several times before and refused to do so. The complainant stated she and her staff observed the defendant in the parking lot checking car door handles, and the defendant stated to the officer that she had not asked her to leave the location and that she had not done anything wrong. That's what the defendant stated, but yeah.
So
the complainant stated she had been asked to leave, and the defendant stated she was not. But the defendant did say to the officers that she was asked to leave several times, and she refused to do so.
At this McDonald's?
At the McDonald's stop.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. Do not go back to this McDonald's, please. I'm making that a condition of your bond. Do not pick up any new cases. You were able to get out because we gave you a free bond. If you pick up a new case, you violate conditions. I'm going to revoke the bond. I'm going to make it high. If you don't have anyone to make that bond, you'll be stuck like Chuck in there. So consider this when you're out there. Please don't pick up any new cases. Be nice.
John,
Tell me, do you have the ability to hire a lawyer?
I don't.
Okay. Would you like us to appoint you a lawyer?
Yes, sir.
I need you to fill out an application for me, Ms. Bourgeois, and then I'll take a look, and assuming you qualify, I'll provide you a lawyer today. Okay? Do you mind, Deputy Brown, giving an application, please? All right. I'm going to have you, we'll give you an application. We'll have you sign a reset, and then I'll have you take a seat in the jury box. Yes, ma'am.
All right, page 2.
So can you file those conditions?
Returning to McDonald's?
Yes.
Yes, sir.
Is this Trey Carter?
Yes, sir.
Mr. Carter, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 2nd, 2025, the officer observed the defendant's vehicle traveling at the 700 block of South Battleground Road, and the officer ran the vehicle's license plate, and the registration was expired as of 2021. A traffic stop was initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer smelled a strong odor of marijuana, and the officer could see marijuana debris laying on the center console. The defendant admitted that he does smoke marijuana, but that he did not smoke that day. The defendant advised he was in possession of a firearm inside the vehicle center armrest container directly to the right of the defendant, and the defendant does not have a license to carry. A PC search was conducted, and the officer found the handgun inside the center armrest container and a full blunt that contained a green leafy substance known to be marijuana based on training experience. The weight of the marijuana was 0.28 ounces.
Mr. Carter, I'm going to find that there's probable cause to go forward with the case. Did you run his license? See if he has a valid Texas driver.
All right, Your Honor.
Please.
It's eligible, Your Honor.
Okay. You are not allowed to drive unless you have valid liability insurance in addition to a valid Texas driver license. I'm not putting any conditions on your bond now. Just be careful. Do not pick up any new cases. If you do, you become a danger to my community. I'm going to revoke your bond. I'm going to put you in jail. Do you understand? Tell me, do you have the ability to hire a lawyer?
No, sir.
Sorry?
No, sir.
Okay, I'll have you fill out an application because I need you to fill one out. And assuming that you qualify, I'll provide you a lawyer today. Okay, please.
Judge, was that stage bond conditions?
No conditions. Yeah, no conditions.
Next, Judge, is page 4. Green, come on up.
Good morning, Mr. Green. Are you chewing gum? Please spit it out. Hey, guys, is there a trash can over there? She's not smacking. Mr. Green, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, the officer observed the defendant's vehicle traveling on the 8600 block of Colon Boulevard, and the officer began to approach the defendant's vehicle and observed a strong odor of marijuana emitting from that specific vehicle. The officer observed the defendant to make a westbound maneuver onto Belfort Street, and the defendant failed to use a right signal to make a turn onto another street. The traffic stop was then initiated. The officer made contact with the defendant and observed the strong odor of marijuana from the vehicle, and the officers asked the defendant to step out of the vehicle, and the defendant was then detained. The officer asked the defendant if he had recently hotboxed the vehicle, and the defendant stated he had earlier in the day. The defendant stated he had marijuana in a backpack lying on the passenger seat, and the defendant stated he had a rifle and pistol magazine. The officer observed a semi-automatic AR pistol lying on the passenger seat adjacent to the backpack with marijuana inside. The backpack had a bunch of Ziploc baggies containing marijuana, and the weight of the marijuana was 13.05 grams.
Do you have a valid Texas driver license, please?
I'll run it, Your Honor.
Mr. Green, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand?
It's eligible, Your Honor.
Unless you have a valid Texas driver license and liability insurance, you're not allowed to drive. Do you understand?
Sir.
Do you have the ability to hire a lawyer, sir? How old are you?
23.
Okay, I'll have you fill out an application to see whether you qualify, and then if you do, then we'll provide your lawyer today. Do not pick up any new cases. Don't violate the law. If I find that you do, I'm gonna put you in jail. You understand me? All right, come on.
Judge, was the state gonna file conditions for Wilson?
No, just, you speak English, sir, right?
Yeah, if I need help, I can.
Would you like me to provide you a translator? What do you speak?
Pashto.
Pashto. How well do you speak English?
Go ahead and sign.
How well do you speak English?
Good. I graduated from high school here.
Okay. Mr. Hashimi, you were charged with driving while intoxicated. You were facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. If you do not understand something, let me know. We'll go slow for you, okay?
If I not hire the attorney, you know what?
We will get to the attorney later. We're doing probable cause now. Do you understand?
Yes.
We're going to see if there's enough evidence to go forward with your case. You have the right to remain silent. Anything you say can or will be used against you. Do you understand?
Yeah.
If you cannot afford a lawyer will be given to you.
I did it.
Stop. Don't say anything. Just, please.
Yes, Judge. On January 3rd, 2025.
Go slow.
At approximately 10 p.m., the officer observed the defendant's vehicle run a red light after the officer was sitting at a cross section with a green light. A traffic stop was then initiated, and the officer made contact with the defendant, who was the driver and sole occupant of the vehicle. The officer observed watery eyes, thick-tongued, slurred speech, confusion, and disorientation. The officer asked the defendant for his driver's license, and he began searching for his wallet, and the defendant then handed the officer his license. The defendant then began making furtive movements, and the officer asked the defendant to exit the vehicle. The officer observed the defendant to stagger and sway on his feet, and the officer could smell an odor of marijuana coming from the vehicle. The defendant admitted to smoking a cigar of marijuana with a friend, and standard field sobriety tests were conducted. The defendant could not follow instructions for the HGN, and the walk-in turn found 7 out of 8 clues, and the one-leg stand found 3 out of 4 clues. The defendant was read the DIC and consented to breath. The results were both .000, and a blood search warrant was signed and executed.
Okay. What was the stop for?
Running a red light, Your Honor.
Okay. Mr. Hashimi, I'm going to find there's enough probable cause to go forward with the case. Would you like me to provide you a lawyer today? Okay. I need you to fill out an application for me. I will take a look at it. If you qualify, we will provide you a lawyer today. Okay? Please, wait, hold on. Mr. Hashimi, you are not to consume alcohol or illegal drugs. I will test you. If you test positive for alcohol or illegal drugs like marijuana, I'm going to put you in jail and revoke your bond. Do you understand?
Yes, sir.
Do you see that he has a?
He's eligible, Your Honor.
Okay, please.
Next, Judge, counsel is approaching on page 7. Jack, come on up. Page 7.
Oh, it's Jack. Mr. Jack? Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 4th, 2024, at 9:02 p.m., the officer arrived on scene to a traffic stop. And upon arrival, the officer met with another officer who stated he had called him for backup after initiating the traffic stop for the vehicle reaching speeds of up to 108 miles per hour. The officer observed a strong odor of an alcoholic beverage, slurred speech, watery eyes, and unsteadiness on his feet. The defendant was then detained, and the defendant admitted to having a few drinks at a party. The defendant refused further questioning, and standard field sobriety tests were conducted. HGN 4 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The DIC was read, and the defendant refused to provide a sample. A blood warrant was signed and executed.
You say what had the odor of alcohol, slurred speech, bloodshot eyes? I didn't hear you say any of that.
Yes, he had odor of alcoholic beverage, slurred speech, watery eyes, and unsteadiness.
Got it. Okay. Mr. Jack, I want to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, it's not going to go well for you. If I find that you're driving like this, in this manner again, I will take your privilege to drive away from you. Do you understand?
Yes.
Do you see that he has a valid license?
I'm running it, Your Honor. It's eligible, Your Honor.
All right. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. They come back to me, tell me they can't get a hold of you because you're playing games. I will issue a warrant for your arrest. You understand? Don't pick up any new cases. Don't use, stay in contact, and all will be fine. All right. I'll have you sign a receipt with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go. Thanks, guys.
All right, Judge Sims is approaching for page 11. Plowman, come on up.
Good morning, Ms. Plowman. Good morning. I wanted to let you know that your lawyer is here with you. He's on Zoom so that you can see that you're not alone. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. Thanks. On January 3rd, 2025, the officer was dispatched to a shoplifting at Target in Harris County, Texas. The defendant had been caught by the complainant, the loss prevention employee, and the defendant was observed pushing a shopping cart with multiple items towards the front entry without paying for the items. The defendant had passed points of sale before the complainant stopped the defendant. The total was $332.49.
All right, ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to go back to any Target. If I find that you go back or you pick up a new case, I'm going to revoke your bond and put you in jail. You understand, ma'am? You have a lawyer. Because you have one, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Sims, and he will tell you when you have to come back to court. If Mr. Sims is unable to get a hold of you because you're playing games, you're not responding to phone calls, text messages, and likewise, I'll revoke your bond. We'll have you sign a reset. I'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go.
Case 8, Judge.
Got it. Good morning, Mr. Lee. Sir, you were charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 5th, 2025, the officer was conducting surveillance as part of a traffic crimes task force of motor vehicles racing westbound on Grand Parkway, and the officer observed the defendant's vehicle traveling in lane 2 and another vehicle in lane 1. The motor vehicle slowed down to approximately 30 miles per hour before launching at the same time in a competitive manner, accelerating to well over 110 to 125 miles per hour in an attempt to outpace each other. The motor vehicles raced 3 times, then pulled into a Buc-ee's. The officer observed the defendant, but was unable to locate the other motor vehicle involved in the race.
So then it says also he picked up a felony evading. He was on bond for a felony evading and now he's picked up this case, a racing?
It looks like that's the case, Your Honor. He was on bond for the evading.
I'm taking away your privilege to drive. You are not allowed to drive, Mr. Lee. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat's behind what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This is an affidavit that you're going to promise me that you're not going to drive. Do you understand? There's a burning building with 50 kids in it. I don't care. Do not drive. You mind filing those conditions as well, please? No driving.
No driving. Yes, Judge.
Have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Johnson. He will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, you pick up another case, I'm going to revoke it. And if I find that you're a danger to the public, I'm going to make it sky high. I will do everything in my power to protect my public at all costs. Do you understand? You want the same day as the felony? Yeah. Okay. All right, guys. I'm going to have you sign a reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. All right. Thanks, guys. Good morning, Ms. Pace. Ma'am, you were charged with driving on a suspended license. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 2nd, 2025, the officer observed the defendant's vehicle at the 900 block of Burke Road. He ran the license plate and it had a return of an expired registration as of November 2024. A traffic stop was conducted, and the defendant was not able to provide a Texas driver's license, so instead the defendant provided a name and date of birth. The defendant stated she did not have financial responsibility on the vehicle, and the defendant was shown to have a suspended driver's license not eligible with multiple Class C warrants.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case.
Can I say something?
Please don't. You have the right to remain silent. Exercise that right. Do you have the ability to hire a lawyer?
Yes, I do.
You don't want a court-appointed lawyer? Okay, so we'll give you time to go hire a lawyer. I am making it a condition of your bond that you're not to drive unless you have a valid Texas driver license and liability insurance. And I'm going to have you sign a promise with me today. Doesn't matter what's going on in your life. If you want to drive, go get a license, get liability insurance. If you can show me that, I'll take this restriction off. Happily. Okay? Okay, man. So I'll have you sign this reset. I'll have you get with Victoria for a reset and then we'll get you out of here, man. Okay? Thank you.
All right, Judge, next is page 11. Reyes, come on up.
Good morning, Mr. Reyes. Sir, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 2nd, 2025, the officer was riding with HPD Traffic Crimes Task Force and a group of vehicles was meeting at 430 West Parker Road in Harris County, Texas. The officer observed the defendant, who was 18, brandish a firearm while walking around his vehicle, and the defendant exited from the motor vehicle on the driver's side, walked around the motor vehicle while brandishing the handgun, and then sat in the front passenger side seat. A traffic stop was initiated and the officer made contact with the defendant, the passenger of the vehicle, and the defendant admitted to carrying around a handgun, which was found under the passenger seat in the motor vehicle where the defendant was sitting.
Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. What are you doing with yourself these days? Are you in school? You graduated from high school? Okay. I'm ordering you as a condition of your bond not to be in possession of weapons. You are not allowed to have a weapon. Do you understand? If I find that you have a weapon, you pick up a new case, I'm going to revoke your bond. I will put you in jail. You understand? Tell me, you want a lawyer?
I'm hiring.
You don't want a court-appointed one? You do one? Okay. I just fill out an application. Let me see if I have an application on file. I need you to fill out an application for me. Let me take a look at it and then I'll appoint you one here in a bit. All right? Come on. Do you mind, Ms. Brown, giving him an application?
All right, Judge, next arraignment is page 13.
Can you
Scott,
file?
come on
No.
up. Counsel, do you have an arraignment?
No, approaching for bond violation.
All right, we're doing the.
Bear with me. I think we're close. Are you Mr. Scott? Mr. Scott, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, in Harris County, Texas, the officer was dispatched to an assault. The officer met with the complainant who stated that the defendant and her had been in a sexual relationship, and she confronted the defendant about sleeping with another woman. The defendant became angry and followed her to a gas station where he pushed her to the ground with both hands, causing pain.
Okay, Mr. Scott, I'm going to find that there's probable cause to go forward with your case. Do we know, have you spoken to her to find out what she wants? Does she want to have contact with him? Does she not want to have contact with him?
Your Honor, we have not reached out at this time.
Okay.
Well, Judge,
Hold on a second. Just don't say anything at this point. I've got a bunch of DAs here. Whatever you say, they can use against you. I can give you a lawyer today if you want one. You know, you can give your side to the lawyer. The lawyers can talk to the DAs, but I don't want you to say anything to make the case any worse. All right. Because I don't know what she wants, I'm ordering you not to have any contact with her, not to be in possession of any weapons. I'm also entering what's called a magistrate order for emergency protection that identifies Ms. Walton as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate any threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Judge, you know the property that she lives, I paid for and proved out on another stating the law and get the homeless rights.
Let's do this. Let me give you a lawyer today. I can have them reach out to find out where she lives, what the address is. I just don't want you to have contact with her. I don't want you to go where she lives or where she works. That's it. Okay? I don't know. Let's do this. Let me give you a lawyer and we'll go from there. Okay? Do not leave until you sign our bond conditions though. Sorry?
Thanks for respecting now my kids, if you're represented in court 1990.
Okay. So hang tight with me. We'll help you out. Don't worry. Okay? Please.
All right, Judge. Next
Yeah, I want to
is
do them all.
page 5.
This is Scott.
Gutierrez,
Scott.
Angel.
Top of page 13.
Oh, sure.
Mr. Gutierrez, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, at approximately 12:58 a.m., the officer observed the defendant's vehicle with no expired registration as of July 2024. A traffic stop was initiated and the officer made contact with the defendant and driver of the vehicle. The window was not completely rolled down and the officer observed slurred speech and further discovered the defendant had an open warrant and asked the defendant to step out of the vehicle. The officer observed an odor of alcoholic beverage and bloodshot eyes, and the officer did search of the defendant and found a marijuana blunt in the defendant's front pocket. The defendant stated he was coming from a bar and was driving home, and the defendant stated he had 1 cocktail drink and 2 shots. The defendant admitted to smoking the marijuana before going to the bar in the car, and the defendant stated he was 3 out of 10 drunk when asked to rate his intoxication. The defendant refused standard field sobriety test, and the DIC was read to the defendant, who refused to provide a breath sample. A blood search warrant was signed and executed.
Mr. Gutierrez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. Do you understand?
Sir.
He has a prior FSRA and he's on bond for that case. Has anything happened to that because of the
I
DWI?
just signed on to that case. He was just recently arrested for it. We're in the beginning stages of this.
Did it to be?
It was. We're in the beginning stages of discovery, Judge. I know almost nothing about that case yet.
Was there a dead body?
No, no, Your Honor, it was a minor injury.
Great.
Yes, Your Honor, this is a leg injury.
On the FSRA?
On the FSRA, yes.
Okay, all right. Does he have a Texas driver license?
It's eligible, Your Honor.
All right, you are not allowed to drive unless you also have liability insurance. If you don't have liability insurance with your Texas driver license, you're not allowed to drive. If I find that you're driving also without insurance, I'm going to revoke your bond. Do you understand? All right. Now you got a great lawyer. It's your responsibility to listen to Mr. Coyne and he'll tell you when you have to come back to court. If he tells me that you're playing games, you're not responding to phone calls or text messages, I will issue a warrant for your arrest. Don't pick up a third case. 3 strikes. You know what happens, right? All right, come on.
Good morning, Judge. May I approach?
Yes, ma'am.
I'm here on an arraignment.
I'm ready when you are. You mind bringing them up?
Yes.
Please. Good morning, Mr. Barragan. You were charged with racing on a highway. You were facing up to a year in jail. I'm sorry, up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 5th, 2025, the officer was part of a street racing and takeover task force and was advised of a group that met at a gas station parking lot in the city limits of Harris County, Texas. The officer was working in a plainclothes capacity and was following the group from one location to another and viewed 2 vehicles race side by side at Highway 290 and Kickapoo Road, traveling westbound. The officer observed the defendant's vehicle and another vehicle slow down to approximately 50 miles per hour before launching at the same time in a competitive manner, accelerating well over 100 miles per hour in an attempt to outpace one another. The officer maintained visual and was able to detain the defendant, the driver of the silver Nissan observed, but was unable to locate the other vehicle.
How fast are we talking over 100?
Let me see if he specified, if it was just that. The officer only said well over 100. He didn't specify.
Barragan, I'm ordering you as a condition of your bond not to participate in this kind of activity again. If I find that you're racing, if I find that you participate in any kind of street takeovers, anything of this nature, reckless driving, donuts, whatever, I will take your ability to drive away from you. Do you understand? Not only that, it is a condition of your bond, and if I find that you do, I can revoke your bond and put you in jail. Can you file those conditions, please?
Yes, Judge.
You're going to reset your case to give you time to fight this thing. I'm going to have you sign a reset, Victoria. I'm going to have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And then after that, you'll be free to go. You have a lawyer. Because you do, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you she can't get a hold of you because you're playing games, you pick up a new case, you've become a danger to my community, I will put you in jail. You understand? Okay, come on. Thank you. Mr. Worthy, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 8th, 2025, the officer responded to a DPS agent who stated he was following the defendant's vehicle and needed assistance on the traffic stop, as the DPS agent was conducting surveillance on an unrelated case. The DPS agent provided a description of the defendant's vehicle, and the officer observed the defendant's vehicle failing to signal a lane change, along with the defendant's third brake light being out. The traffic stop was then conducted, and the officer made contact with the defendant. The officer observed a strong odor of marijuana, and the defendant was asked to step out of the vehicle, and the defendant stated there was nothing illegal inside. The officer located a cigar filled with a green leafy substance known to be marijuana based on training experience with a weight of 0.09 grams or 0.032 ounces. A PC search of the vehicle was conducted, and the officer located an unholstered black handgun inside a backpack in the back seat of the vehicle.
Mr. Worthy, I'm going to find that there's probable cause to go forward with the case. Take a seat for me in the jury box.
So this is Mr. Worthy.
Mr. Worthy.
Yes, Your Honor.
You were placed on probation. You were on probation for unlawful carrying of a weapon. Now you've picked up a new case. So we are now filing a motion to revoke your probation, and a warrant's going to issue. We will take you into custody now.
We would ask if we could set this for a hearing on the MAJ before we take him into custody.
Yeah, I mean, he picked up a new case. He's on probation. What we do is when any pick up a new case, motion to revoke gets filed. That's the normal course of business. You're supposed to not pick up a new case, right? Okay, goes to the. Did I sign it? I need to sign. Yeah, have I signed it? Okay, right now.
Judge, what's the new bond amount?
We talk about the new bond amount?
Yes, Judge. But I need to talk to him about what he's doing and living with and working, all that good stuff, so we can have a better conversation.
Okay, so I'll set it at 5. What's it at now? Okay, 5,001. Yeah. Okay, so just let me know. Whatever you want, if you want to set it a couple days, maybe to Monday, Tuesday.
Okay.
If he's unable to, we can talk early next week.
Okay, Judge. I'll go talk with him.